It's that time. We're live again. Hey there, Christian Walsh, real estate agent with Wire Associates. We've been helping renters and landlords understand their rights before things go wrong. Unfortunately, a lot of people end up calling me after things go wrong, but we're still here to help. So it is a big day today. We've got a lot of ground to cover. I'm going to bring on our experts, the guys in ties, as I always like to say. Let's see. Zach, welcome. Applause for you.
Thank you.
Kenny's still prepping. He's in the green room. Oh, he's coming. I'm going to give him another 30 seconds or so. Zach, how are you, my friend? I like the new haircut. Looks good. Looks sharp.
Thank you. Yeah, I feel a lot slicker. Feel like I can run, jump, swim. There you go. A little cold up top, but yeah,
Yeah,
there
we
you go.
won't keep you too late. You got to get to your triathlon after this. Now that you got the haircut done, and one of the things we're going to cover. All right, let's see if Kenny, are you there, my friend?
Yeah, I'm here.
Woohoo! Hold on, applause for you, Kenny. Kenny, move the camera down. You look like a little kid who needs to sit on a phone book. Okay. All right. And remember, I can't give tax or legal advice, but the guys in ties can give legal advice. We always encourage you to reach out to chat with them. And one of the first things we're going to dive into is the trade show, the AOA Trade Show, which is where we were yesterday. Had a lot of fun there, and Kenny was there. Zach couldn't join us, but that's okay. He'll be at the next one. Kenny was there. Christina was there. So, Kenny, tell me, my friend, what were some of the most common questions that you found yesterday amongst the people who came up to you, because you were swarmed at certain times.
Yeah.
And by the way, people were coming up to our tables. They literally took everything from our table. Like, we ran out of all business cards and flyers. Some of it wasn't meant to be taken. It was just meant to like scan QR codes, but it's in somebody's bag at home right now. So anyway, so Kenny, tell me some of the most common questions you had.
Yeah. So I think that when it comes to evictions and landlord-tenant laws, California is a very notice-heavy kind of state, and they also kind of just like compliance with just giving out notices. Whether or not there's actual notice or not, that's kind of left up into the ether. But as long as you comply by giving written notice or mail notice, anything that you would be in compliance with the laws, I think that's what the statutes are looking for. And the questions that I got quite heavily, actually, that I was a little bit perplexed by was, doesn't it show some kind of weakness? Doesn't it show that, like, if I give them notice about these protections, that the tenants might say, oh, like, look at all the strength that I have, look at all of this kind of protections that I have, and the take that I had in terms of a lot of compliance issues is it actually shows the opposite. When you comply with state law, when you comply with local jurisdiction laws, that actually minimizes the defenses that tenants can bring forward to you, and it puts you in a position of power and strength at trial. There's a reason why you don't have to be this ultra aggressive, I take everything that's worth mine and you get nothing kind of thing. A lot of the times you can work things out with people, because at the end of the day, you have a contract and people are going to try to work it out. But when you comply with the law, when you do what the law says, and you learn about the law, and you make sure that you're in compliance with everything, the judges, they can't take the tenant side at that point because you don't give them ammunition. You don't give them the power to say, oh, well, you didn't give me this notice. Oh, well, you didn't register properly. You didn't pay this fee. I understand, and this is something that I've also kind of voiced out as well. Some of the laws I don't quite understand myself. I don't understand why or the purpose as to why they are doing it this way. And unfortunately, that's a political question. That's a political issue. And some of the, quite frankly, some of the members on the LA City Council need to be questioned as far as what their understanding of what the law says. Because I've had discussions with some city council members, and I've told them how the judges are actually interpreting their laws. And I remember talking with John Lee, one of the city council members, straight up telling me, "Oh, that's not what our law says." And I said, "Oh, okay, great. How about you tell the judges that, because the judges aren't reading it that way." And he said, "No, there's no way a judge would read it that way." And I told him, "I'm in court every day, and judges are telling me this is what you wrote." And he's like, "Oh, okay, yeah, then we need to fix that." And that was the end of it. And I've been following up with his office, every month and a half saying, hey, when are you going to fix this issue in related towards tenancies at will? No response, no response. But again, that's a political issue. That's a political question, and I agree. It's going to get worse before it gets any better. You're going to see a lot more restrictions. You're going to see a lot more notice requirements. One of the things that I've been seeing is that in LA County, unincorporated parts, they have a rights to counsel, kind of treating them like public defenders, being paid out by taxpayer money. And then now certain other incorporated cities are still trying to consider if they should implement something like that with the money that they may or may not have to pay for this. But again, the biggest question I had was, do I have to comply with these laws? And emphatically, my answer is always yes, 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 because it puts you in the driver's seat. It lets you take control of what's going on. And it in no way shows weakness whatsoever, because again, you don't let the judge take control of the situation. You take control.
So, Kenny, if I can, this is an example of a notice that you would give. So we're not just talking specifically 3-day notices and things like that, or 60-day notices. We're talking about like required notices. So this is the LA City Renter Protections Notice, and I've done tons of videos on this. It's constantly being updated. So this one's from March 28th. And the updates now at this point in time are relatively minor. But I was shocked at the number of people that hadn't seen this with LA City properties, and the number of people that took our copies. I printed like 10 copies. we had to hold on to that last one for dear life because people wanted this. So we started sending out links. But this is an example of what you're talking about. Like, this isn't, you're not showing weakness by giving this. You're following the law. You're supposed to post this in a public place. That includes for single family homes and condos. Put it on the garage, whatever, take a picture. And then any new renters moving in, they need to get a copy of this. And there's a lot on here. They may misunderstand it, whatever, but that's not our problem if they misunderstand it. So that's one of the things I was surprised by, is the number of LA City landlords that hadn't seen this thing. So
yeah, and look, Christian, the thing that I want first and foremost, and I think this is what everybody wants, is I want these cases to be adjudicated on its merits. And when I say the merits, I mean, hey, like, what's really going on? Is there a payment of rent situation? Is there a habitability situation? What is really going on? And when you don't comply with these ticky-tacky procedural technical defenses, all of a sudden at court, you're not talking about what the parties care about. You're talking about what the judge cares about, what the legislature cares about, what the attorneys care about. And it doesn't go to the heart of the situation. And I'm really, I get frustrated when I see that, where it's like, hey, the attorneys are talking about, did you actually write the number of bedrooms on the notice? Did you actually write the fair market value of the unit itself? Did you meet that fair market value threshold number? Did you register the unit? At the end of the day, nobody will actually sit there and say, I'm suing you because you didn't write down the bedrooms on my notice. No one's going to sue over that, but they will sue over rent that wasn't paid. They will sue over breaches of the contract itself, and they'll sue over nuisances, right? And those are things that matter. But in order to get there, you need to make sure that you're in compliance with the law, so that the judges don't take that power away from you. The courts don't take that power away from you. Because once you comply, you rein in that power and you say, give me what I'm looking for because this is what I'm entitled to do.
Kenny, you're on fire today. I like this version of Kenny. So we're going to come back to this because there's a few other things that surprised me at the show, but I don't want Zach sitting there feeling lonely. He couldn't make it to the show. He was busy with other stuff, but I don't want him to be lonely. So Zach, tell me what you're seeing, boots on the ground. This year we have the new requirement that when an unlawful detainer is filed, that instead of 5 court days to answer, renters now have 10 court days to answer. What are you seeing? Is that really adding some wrinkles into the process?
Yeah, it slows everything down to be certain. It'll come up, for example, if you have, let's say, multiple tenants. So one tenant gets served and is really easy. The other one is either evading service or for whatever reason can't be served, and you want to do an order to post. The longer timeline means that the delay in the case goes through the roof. Or sometimes there'll be a problem with service. They'll move to quash service, and you're wasting even more time. There's uncertainty with regard to if a demur gets sustained, how much time should the tenants get to respond? or if a demur gets overruled, how much time should the tenants get to respond? So I think that, one sort of minor procedural change has caused a lot of uncertainty and a lot of delay in the process. Obviously, the best way forward is for everything to go according to plan and for everything to go right. But what this is meaning now is that when things go wrong, it's taking longer, in some cases significantly longer, to move the case forward.
That's it. I love that perspective. So those are the unintended consequences. And actually dovetails back into what you were talking about, Kenny, where legislative branch legislates and then judicial actually enforces it, and they're not talking and discussing these unintended consequences, or like you were talking about, Kenny, misinterpretation of what the legislation was actually saying. So
I mean, I would say that it's more the legislators not really doing their homework carefully,
yeah.
and actually understanding what's going on. And then when they actually get feedback, they're like, "No, that's not what we discussed."
Well, go to a courtroom there, dude and dudette, so you can see how it's being implemented, and maybe not write it like that in the future. What else are you seeing boots on the ground, Zach?
Yeah, I think that there are a lot of recent changes that are still working their way through the system, because essentially you have judges who do unlawful detainers every single day. You have judges who maybe have never done an unlawful detainer, who do virtually no unlawful detainers. So in unlimited civil courthouses, or if you get sent out for a jury trial and you're in front of a judge that maybe doesn't handle a lot of unlawful detainers, they are not necessarily going to be up to date on all of the newest changes. So to give you an example, demurs are required to be set on a very short schedule. In unlimited civil cases, they're used to demurs being set months out into the future. In unlawful detainer, they have to be set between, I believe, 3 to 7 days. Much, 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 much shorter, right? For a demur in regular civil, it wouldn't be uncommon to see one set, like I said, several months in the future. So trying to process all of the law changes and disseminate that knowledge to all of the people who are involved in actually making the cases go forward. That's the attorneys, that's the litigants themselves, that's the judges. That whole process takes time. And every time you think that you've caught up, something else changes. So it is really a pretty fast moving, changing legal environment. Give you an example, just recently they banned, for example, substantial renovation cases, and we happen to be working on substantial renovation cases in the city of Los Angeles. Had to make a very interesting phone call to clients and say, hey, when we took in your case, the law was one thing, and then 60 days passed and you thought we were going to do an eviction. Turns out the law changed and you're not going to get to do an eviction. So that's how quickly things can change. But notice there that, essentially we happen to be up on that law. You can imagine that other litigants, particularly self-represented litigants, other attorneys, judges themselves, it takes time for people to process all of this information. So yeah, I think that the court system is still digesting, let's say, the most recent round of legislation.
That's a great point too there, Zach. And that you're right, the substantial remodel provision was removed from LA City's just cause ordinance, and reason being they claimed that there were just thousands of these being filed. I ran the numbers and it was less than 100 of the substantial remodel cases. The 50,000 eviction cases were actually the majority were non-payment of rent. So I've said this before, I'll say it again, that would be the real solution. Quit wasting time on a real minor problem, so to speak. And it's not even a minor problem. It's a right of someone who owns their property to get possession back so they can fix it up. But anyway, that was an emergency ordinance. And they said that basically, even if you had given notice 59 days ago, day 60 was the day after, you still couldn't. It wasn't valid anymore. And to your point, Zach, you guys are up on this stuff and you know it. Will be people still somewhere in that notice period that don't know about it and still show up in court and lose. It'd be pretty embarrassing, actually, to show up for that.
It actually gets even a little bit more devious than that, because if you haven't filed your lawsuit yet, well, you've lost 2 months of your time. This applied to cases that have been filed, and
Yeah.
judgments haven't been issued. So there were cases where they were in the middle of a trial. Literally, trial was either the next day or they were in the middle of a jury trial, and then the defense comes forward and says, "Hey, the law changed. Actually, I just win." And courts have said, "Oh, you're right. You just win. Even if you had just filed this one day before, because judgment could have been entered tomorrow, you just lose your case now." So, like I said before, the legislature is going to move things, break things, change things, and you need to be prepared for that. And the way you be prepared is actually trying to understand the legislature and see what's actually changing and complying. Because again, when you comply with what the law says, you take that power away from judges to do exactly what they did in those substantial rental cases, where they said, you know what, like I'm just going to say you lose, because when you comply, the judges can't do that.
No, I appreciate you sharing that, Kenny. That's unbelievable. So don't forget, we have Michelle in the background. She's working away, keeping the comments clean. And we got some comments starting to come in. One of the other things I wanted to talk about briefly that I found interesting amongst the folks I was talking to at the show is just how many people are worried about legislation. And this is specifically landlords are worried about legislation that's in the works in Sacramento and the repercussions of that legislation on them as landlords. And what's interesting to me is a lot of sleepless nights by landlords when a lot of this legislation ends up changing. Now, if they don't like the legislation while it's being written, they should definitely reach out to their Congress people and let them know. But for example, AB 246 was a rent freeze law for LA City that was being basically created at the statewide level in Sacramento. They were going to freeze the rent due to fires, even though LA City and LA County ultimately decided not to freeze rents. They were still going to do this, and the can was kicked, and ultimately it was changed into a Social Security Renter Protection Act. They dropped any reference to a rent freeze in LA City or LA County, actually. So it's important to follow legislation, but also don't lose too much sleep until it gets closer to being passed, because it can change dramatically. And when it's finally passed and signed into the law, that's when we all start to adapt and figure out how to live with the new legislation. I like to describe it as trying to color in the lines in a coloring book that's constantly changing. That's essentially what we do. And that's what I do as a real estate agent, helping landlords sell their properties with renters in. And we got a color in the lines and a coloring book that's constantly changing. And you guys too, you got to evict people in a coloring book that's every day new pages. So
Yeah.
anything else, Kenny, at the show that you talked a lot about?
I mean, outside of the legislative issue, I think with the political climate being in the way it is, you are going to see a lot more legislatures changing their laws almost on a monthly, if not weekly basis at this point, because they're still learning, they're figuring things out, they're copying, pasting, doing the thing that they're going to do. So yeah, it's really important nowadays that you have to be caught up to date as to what affects your property, because if you don't, you are going to run into a lot of situations, especially from what I talked to prospective landlords or landlords yesterday, was that, oh, well, I didn't know that if I don't raise the rent on my tenant for the past 20 years, it's going to come back to bite me. And it's like, that's the climate that we're in nowadays. And, it's going to become more aggressive. So you need to actually take proactive steps to protect your interests, to protect your property rights, and make sure that you're not going to just be taken over by the legislature that's going to be potentially passing more legislation that's going to hurt you.
And when you copy and paste a legislation with flaws in it and bring it to another area, the flaws come into that area as well, which is not handy. And that's as far as rent increases go. Let's talk about that for a second. So, Tenant Protection Act, which I've released a ton of content on, and there's good reasons for the Tenant Protection Act, and it really what it boils down to is bad apples have led to legislation. But the Tenant Protection Act, for properties that are subject to it, it allows rental increases of 5% plus CPI, no higher than 10%. New numbers are going to be coming out. I'll have a video on that. And where I'm headed with this is it's use it or lose it. So a lot of landlords who didn't increase rent all that frequently, they maybe do $50 every couple of years. And a lot of renters watching this are like, man, I wish I had that guy or gal. But those landlords now have to increase the rent. Costs have gone up. They now have to increase the rent. And that's why we're seeing sometimes what would have been $50 now is 8.9%, which is the maximum. So going back to unintended consequences, that's what happens. So we were trying to protect certain people, and other people, unfortunately, are getting hurt. And when I say people getting hurt, I mean renters who see their rent increased every year at this 5 to 8% level. So, and there is legislation that is in the works from Sacramento to reduce the limit, the max from 10% to 5%, but it's unlikely that'll pass, in my opinion. But don't lose sleep over it until it's closer to passing. All right, so let's dive into some questions here. We have Only in America, who lives in Burbank. Tenant was pressured into signing a buyout for a remodel that didn't take 30 days. Can the tenant sue the landlord for fraud? What compensation could they get, and how much approximately? So what's interesting to me on this, and I'm going to let you guys dive in because you're the experts, but if you signed a buyout versus receiving a substantial remodel notice of termination, I would think there'd be different paths for retribution. I want to clarify on that. But if you accept the buyout versus having a 60-day notice of terminate tenancy being given, and it didn't take 30 days to do the remodel, which is what the law requires for a substantial remodel. Anyway, dive in, guys. Let me know what you think on this.
So I don't think it would be fraud. You could maybe do wrongful eviction, but I mean, essentially, fraud would be that you in reliance on an intentional misrepresentation, took some action to your detriment. So maybe here the idea is that the fraud is that it didn't take 30 days. I don't like fraud necessarily when the conduct's in the future, right? So I don't know that fraud is the best fit. Compensation, you'd be entitled to, let's say, actual damages. So, let's say it turned out that the landlord engaged in a sham eviction to kick you out. Presumably you'd be entitled to the delta, the difference between the rent that you actually did pay and the rent that you would have paid had you stayed at the place. And then how much approximately, it's going to depend. So if your rent was, $5 and a comparable unit costs, $500,000 a month, then you're going to have this huge number versus if you left an apartment that was, let's say $1,200 a month and you moved into one that was also $1,200 a month, hard to see, how much your actual damages would be. So it's case specific.
Yeah, and then the buyout, a dollar amount, I'm assuming, might factor into that as well.
Oh yeah, so the buyout agreement. So it's like, so just touching on the idea of being pressured. I mean, essentially, in order to avoid a contract, a duress defense is going to be tough. I mean, that's something like, I've kidnapped your family, or like I'm holding a gun to your head. It's not just, I didn't know what to do and I was scared and I was this and I was that. It really doesn't cut it. For certain kinds of contracts, contracts of adhesion, contracts which are offered on a take it or leave it basis, for which there's no real negotiation and are sort of offered to the public. So imagine that I walk into, a classic contract of adhesion is like the like iTunes or whatever. You know what I'm saying? You click like agree to terms. And and nobody knows what the terms are, and you'd have to spend 100 lifetimes to read all the terms. So if in those terms they put something that's really unconscionable, courts can say that that's unenforceable. But here, when it's a one-on-one with the landlord and the tenant, it's a lot harder to make out the case that this is a contract of adhesion. Yeah.
And I want to, if I can interject, Zach is being very factual here. I don't take this for a minute that he is making light of the situation or discounting the fact that maybe you were pressured. He is just explaining the facts of it. And if you're going to talk to any good attorney, these are the facts you're going to get. If you talk to a bad attorney, they're going to make you think you have a case that you don't have so they can squeeze you for money. Zach is giving you the a realistic view on this. And maybe there was something you can put, maybe there was a gun involved. I know that sounds ridiculous, but maybe there was. So that's what Zach is doing. He's trying to explain that it can be a tough path to go. Landlord dropped a fake unlawful detainer after a year and a half. This person has a harassment case. Can I add that as proof of harassment? Could that increase damages? How much could we get per person if we prove fraud? So this is dovetailing back into the question number one. This is a second part of this question.
Yeah, so making, let's say, so imagine that it was a totally fake case, meaning the case didn't exist at all. Yeah, I think that you could try and make a harassment case out of that. In terms of what your damages are, my gut feeling is that this would probably be appropriate for small claims. But yeah, I mean, some people want to try and go big. But yeah, I mean, I think that maybe small claims would be the best way to handle this. Yeah, essentially, if the landlord makes a knowingly false misrepresentation to the tenant, hey, you need to leave, here's this eviction, you're going to be evicted, and it's totally fake, and they made up a fake case number and stuff, okay, that's something which serves no lawful purpose, and which, I think a reasonable person would find to be, quite stressful. Versus if it's a fake UD because it's you don't agree with it or what. Yeah, if it's a real case, you just disagree with the facts of the case, you're in a whole other territory. California courts really don't like people suing each other because they got sued. So that is, usually if you sue someone unsuccessfully, there is a tort for a malicious prosecution. You'll almost never see one of those cases win.
That's a very good distinction. I appreciate that distinction on how fake is the unlawful detainer. Again, that distinction was you don't agree with it, so you feel it's fake because you don't agree with it. Or the other side was they went into ChatGPT and had it make up completely fake everything, a document trying to make it look official. That would be an extreme fake unlawful detainer. And Zach thinks that's more solid. All right, Kenny.
Wait, Christian, really quick.
Go ahead,
I have a really fun story on that one.
Okay, good.
I recently went to a hearing in regards to an attorney who was making a filing, and he cited some interesting case law that was very on point. It proved his point. It proved his defense. It proved that we couldn't go forward with the case. However, I've never heard of the case. Judge never heard of the case. He himself never heard of the case. The only person that did was the AI bot that he had asked. And he admitted that in open court. And I didn't have to say anything at the hearing. The judge said all the talking. And it just went from bad to worse. He doubled down immediately, said that law doesn't exist. The bot told him it existed. He was like, okay, well, what about this one? That one didn't exist as well. So this idea that, if you're going to do your research and you ask an AI bot what the law says, the AI bot is an aggregate conglomeration of human behaviors at this point. And they're going to look at, citations to case law and say, it's supposed to look like this. I don't know what this really means, but let me just make it look like it's real. Courts are going to actually look at what you file. Contrary to popular belief, they look at what you file and they read what you file. Yeah, he doubled down, and the judge kind of just said, no, this doesn't exist, because if it did exist, all the rulings I made in the past would have just been wrong. And I'm, very good on you for finding this case, but where is it? And
that's amazing.
The best part about it is that the attorney was asking, okay, well then what can I file to have my case heard? And the judge kind of signed it off by saying, you can ask your AI chatbot and it'll tell you what to do.
Oh, that is amazing. And that'll be great too. That judge will always remember that attorney. So anytime that attorney comes in, they're going to have to work 3 times as hard. And good job on your part, not interjecting and not interrupting and letting the rope play out so that he had enough rope to hang himself in the end. So that was good. Good job on your part too. All right. So we got that question for Kenny. Earlier, Kenny had said, had talked about not increasing rent for 20 years. So this viewer is asking you to elaborate. If I haven't increased rent on tenants for the past 20 years, it'll come back to bite me. Why is it a bad thing not to increase rent in the past 20 years?
So the general political climate nowadays seems to be leaning towards harsher and harsher restrictions on what you can do to your properties. You're seeing kind of more of a takeaway in terms of what you can raise the rents to, how much you can raise it by, and how often you can raise it by. So, earlier we had said, or Christian, you had mentioned, it's basically a use it or lose it kind of policy. So let's say that you don't think that it's fair if I was to raise the rent every year on you, and that's actually the general consensus for a lot of landlords. A lot of landlords don't want to raise the rent every year. They just kind of say, well, you know what, like you're a good tenant. I don't want you to feel like you need to leave. I don't want you to have the burden of the additional rent increase. I'm okay with this. Well, under the use it or lose it policy, you're not going to be able to bank that or store that. So let's say 10 years from now, your costs go up, your insurance rates goes up, your property tax goes up, an unexpected capital expenditure comes your way, and you can't pay it off. Well, you can't pass that off to your tenant at that point because you've lost it. You haven't used it, so you lost it. And that's what we mean by that, where if you're not going to use it, you're going to lose it, and down the road, you can't claim that back. So on our end, what the way that I view it is if you want to protect yourself to the fullest extent that you can, you need to use what's available to you legally to make sure that you don't find yourself in a position 20 years on the road where somebody is paying you $1,000 for a 4-bedroom unit in LA. Because trust me, those are out there. And those
Yeah.
landlords don't know what to do with that property because how are they going to afford letting someone stay in a 4-bedroom unit for $1,000, and the amount they can raise the rent by is 4% a year?
Yeah, and to add to that, then unfortunately that landlord passes away and passes that property on to a family member. And because of Prop 19, property taxes are reset to market value. LA County picks a ridiculous market value. I'm talking from experience. And the property absolutely no longer pencils, and nobody will take it because it is so upside down. And all because that landlord wanted to give a deal and be fair to a family for years. That's really ultimately what it boils down to. Okay, so LH has single house tenant has been renting for over 10 years, paid rent on time, been difficult to get along, considering terminating the lease. Part two, LH wants to know how to do it. Serve the notice of lease termination effectively and in compliance with legal requirements. 60-day notice, post stamp mail, already served AB 1482. What else? The big question is going to be is where is the property? That's the next question that these guys are going to ask. It in some places, LA County unincorporated doesn't matter. You're not getting rid of the tenant that easily. LA City, you're going to have to jump through special hoops to get rid of it. So that LH, let us know where the property is, and then we can give you a better answer. You guys concur?
Yeah, so in real estate, there's always that saying, location, location, location. This also doesn't change in eviction world or tenant landlord law as well. Um, the other day, there were many landlords who said, "Hey, like I'm in the city of Van Nuys, I'm in the city of Sherman Oaks," and I'm like, "Okay, those are not cities." And they're like, "Okay, well, where are you?" It's like, "Oh, I think I'm in LA." It's like, "Okay, well then you're under the LA Just Cause Ordinance most likely, or those protections, and that heavily limits what you're able to do." And then you can tailor your discussion to LA city law, and you can ignore the other stuff. But what I saw a lot of landlords doing is they didn't see that their property was in LA. They didn't know where they were. And then they said, well, how do I comply with AB 1482? If you knew that you were in LA, AB 1482 doesn't apply to you then at that point because you're subject to the LA Just Cause Ordinance or the RSO at that point. So
Yeah,
location, 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 that matters
exactly. You
tremendously.
can you can still give the exemption notice for AB 1482 if you're exempt in LA City, but doesn't matter. You got to jump through the JCO hoops, and that's why you hire these guys. Number one, and then number two, if you're selling the darn thing, before you hire another agent who doesn't know what they're doing, and then call me with questions on how to get out of a contract where you're forced to make the property vacant before it'll close, and you have a 6-month extension, and then you drop the price 100,000. That was not made up. That was a phone call I just had this week. Please reach out to me. This is what I specialize in. And these guys we're all on the same team, not in the same office or anything like that, but we're on the same team. We're all working together. So anyway, I'll get off my soapbox. I get these phone calls when things go wrong. How many phone calls do you guys get when things go wrong?
All the time. It's also it's not like the past days anymore where you could file kind of like a microwave piece of paper and then tell the court, hey, they haven't paid the rent, evict them. We get many calls where people file their own paperwork and they tell us to sub in, and I tell them, look, what you filed facially on its face, it's it's not valid. You're going to lose the case. And the thing is, again, this also puts you on a very poor positioning power to negotiate any kind of settlement, because the other side, they're looking at the paperwork that you filed and they're laughing. They're laughing, quite frankly, because they're saying, I know how to win this case and I'm not going to take a deal that's in your benefit because I could just tell the court they messed up. They messed up. And unfortunately, when you file those documents that are invalid, we can't fix that. The only way that we can fix it is by starting over. So in an effort to kind of, cut costs, or in an effort to say, I can do this myself, you've actually lost time. You've lost more money. You probably had to take some Advil for the headaches that you were getting. And at that point, it just wasn't worth it. So you really need to be careful when you get into this field, because a lot of landlords are getting hurt because they try to do this on their own.
Zach, any good stories? And then we'll answer Wayne's question. Any good stories of should have called Zach before they did what they did?
Yeah, I mean, at every stage in the process, there are traps. I mean, people who, would rent out a unit to a family member for a very low rent, very surprised to discover the existence of rent control laws, very surprised to discover the existence of eviction controls. People who, maybe start up a case, really, even good lawyers, I mean, really good, smart lawyers will start up a case, do a notice, you missed, like Kenny was saying, I mean, just something as simple as like the number of bedrooms or something like that. I mean, your whole case is busted. You lose all your leverage. If the tenant has an attorney, it's potential that they could get attorney fees. So from such small amounts of caution and diligence, the whole edifice will come crumbling down. So yeah, I mean, it's just too many to count. It's very, very, very rare that we would see somebody who, sort of did everything right, and one wrong misstep can be fatal. Alternatively, we'll meet people who will be convinced that a particular action that they took is fatal, and we'll be the ones to tell them, no, that's actually just fine. There's a case directly on point, or that used to be the law, but that changed. That happens less frequently. But really, as I believe as Mark Twain said, it's not the things that you don't know that get you. It's the things you think you know that just aren't so. So you really, really, really need to be careful in this field.
I love that. Yeah, I love Mark Twain. Good quote. And you're much more likely to be accidentally wrong than accidentally right, in especially in something as complicated as the law that you guys deal with daily. Wayne, good to see you. You've been on here before. Good to see you again, my friend. Wayne's a landlord. Rental contract states no pets are allowed in the property. Found on social media that the tenant owns a dog with pictures posted. And it is funny. Social media, public social media, the silly things people post on there. Can I charge my tenants after they moved out using the social media as the evidence? Is there a limit on how much you can charge them per day if the penalty is not specified in the contract? So I'm going to obviously let the attorneys talk, but I think one of the challenges here, if your contract says no pets, you didn't put a fee in there that you could realistically charge them for having the pet. So I don't know how you would calculate that backwards. What do you guys say?
So I believe fees are covered in the civil code under liquidated damages, and these kinds of fees in a residential housing context are presumptively void. So if you had like a flat fee, so for every day that you have the dog there, you owe me $50. Those are presumptively void unless the landlord or the property owner can show that the amount of money would be extremely impracticable to calculate or impossible to calculate, and that this number is a pretty close approximation of whatever the true number would be. So it happens all the time. You could sue for breach of contract. You could absolutely sue if the contract says no dogs and they had a dog, you could sue for breach of contract. The question becomes, what are your damages? So it's put me in the position that I would have been in had you complied with the contract. So imagine what that world would look like, and then compare it to this world, and whatever the difference is, those are your damages. Here, absent, let's say, some kind of additional cleaning that you had to do, or something like that, there really aren't damages. You'd be entitled to what are called nominal damages. So you'd get probably $1 if you couldn't show actual damages.
That's a good. I like that. I appreciate that distinction you made there. So you can charge pet rent, or you can charge a pet deposit as long as you don't exceed the AB 12 limits. But that you'd establish that in the beginning, and if you say no pets, you can't really collect a back number.
Yeah, and Christian, just wanted to add on to that as well.
Sure.
With pets, you're going to have to be careful to a certain degree. California, LA, a lot of local jurisdictions have been implementing their own rules in terms of whether or not you can either evict for pets, or whether or not you can even charge additional rent or security deposit or a pet deposit, especially in relation towards emotional support animals. If they ask for a reasonable accommodation, you're not allowed to actually say, well, the reasonable accommodation is I'm going to charge you up the wazoo to basically have you having that pet. You're going to be targeted immediately with the lawsuit if you do that. So you have to be careful a little bit on the pets. Talking about the social media element behind it, I do think that's pretty fun little find in terms of an evidentiary issue. It kind of reminds me about a fairly recent case with Gwyneth Paltrow, where she was being sued for a ski incident for personal injury. And on cross-examination, the plaintiff's attorney kind of got, or the defense attorney kind of got the plaintiff, put him on the stand and said, here's your pictures of your social media. These are the dates that occurred right after your claimed incident, and you're basically saying that you were hurt beyond belief. Here's a picture of you traveling to Rome. Here's a picture of you in the Alps. Here's a picture of you on the beaches. This is all you, right? And where did they get those pictures from? They got it from social media. So you got to be careful about where you post, because people are watching. People are seeing what you're doing. So that tenant needs to be a little bit more careful about what they're posting when they're posting pictures of breaches in their own contract.
Yeah, excellent, excellent point. And that's good advice for renters. If you're breaching your agreement, like, don't put it on social media. Like, if you're remodeling the kitchen in a rental, I wouldn't start up a YouTube channel talking about remodeling that rental. You can get yourself in trouble. All right, so Only in America circled back with some clarification on a few items. There was a worker who was coming around telling people, intimidating people into signing the buyout agreement. There was a 60-day notice and a buyout agreement. So that's interesting. I want more clarification on why there were two separate things. The fake UD, you have evidence that the substantial remodel took less than 30 days. So they tried to coerce us into leaving and threatened with deposition, phone calls. I know who this is because you've been on our channel before under a different name, Only in America, and we discussed this. And you talked to some of the contractors, and it wasn't going to take a full 30 days. I remember this. Since the landlord dropped the UD, I owe back rent. Should I wait for him to ask or reach out first? Could he ignore it since I have a case against him? So it looks like Only in America is going after the landlord for this false eviction. So what are your thoughts?
No. So immediately, this is a trap, another trap for the unwary. So during the pendency of an eviction lawsuit, the landlord cannot legally accept rent from the tenant during that lawsuit. If this lawsuit did take a year and a half, the amount of rent that the tenant otherwise would have owed is still accruing. If the landlord drops that case, loses that case, or doesn't get possession of the unit for whatever reason, the money is still owe and doing, or it's still owed. So you need to still pay that rent. A trap that a lot of tenants go through, and this is something that a lot of tenants I've seen go through, is you need to pay the rent. or else you will be targeted again immediately with a 3-day pay or quit notice. And if you don't pay within the 3 days, well, then they've perfected their right on a more severe case, in my opinion, where their burden of proof isn't as high as I would say for a substantial reno. And you're going to be in a world of hurt because you thought, I have a lawsuit against the landlord, so I don't pay the rent. You need to protect yourself. You need to pay the rent once you get the notice, or if you believe that there's an illegal rent increase, or if you think it's retaliation, assert those defenses properly and make sure that you document that. But it's a huge mistake, in my opinion, when tenants say, I have a lawsuit against the landlord, I'm not paying the rent. You're going to get hit with an eviction, and you may not win that eviction.
So I hope you're paying attention, renters. Make sure you pay your rent. And that's also a good way for renters with unwary landlords or uneducated landlords. If a landlord gives a 60-day notice and accepts your rent beyond the 60-day notice, then it's invalidated the 60-day notice. Correct, gentlemen?
Yeah. And the logic behind that is essentially when the notice expires, the landlord is declaring to the world, this lease is over. You have no right to stay at the property. But if you accept rent from them after you've declared it over, then why are you taking rent when the lease is expired?
All right. So LH clarified. So that property that where the termination of tenancy is happening is in Manhattan Beach. So I'm looking at the map. So you definitely want to make sure it falls in Manhattan Beach. It's definitely not LA City. Is any part of Manhattan Beach LA County unincorporated, guys? You always have to check the map, is what I tell people. I don't care how long you've lived in LA and what you think you know, like check the map. So Manhattan Beach, I'm pretty sure.
It's in LA County, but there are parts of it that might be unincorporated. You could have a
Yeah,
Manhattan Beach City, but
yeah,
still be in an unincorporated part of LA County.
exactly. Same thing. I had an issue with a client in Compton, which was Compton, but it was LA County unincorporated. So that changed things dramatically. So LH, make sure it's definitely Manhattan Beach first. You can reach out to these guys. You can set up a phone call and they'll double check for you.
But just to answer, so yeah, assuming it is in Manhattan Beach and it's the city of Manhattan Beach, I don't believe they have a local rent control. So if you're exempt from the TPA, make sure that you're properly exempt. So make sure that I believe it was a single family home. Make sure that your E8 exemption is spotless. I've seen so many people who give the E8 exemption but don't check the box indicating that it's exempt. So just double check. I would also consider removing any attorney fee provision in the lease if you're planning on essentially serving them a 60-day notice. That attracts tenant defense attorneys. Other than that, at this point, there's not really a whole lot else to do. Don't harass them. Don't retaliate them. Don't stop providing utilities. Nothing like that. And then make sure that you statutorily serve the 60-day notice. You have a couple different choices with the 60-day notice. I believe those can be mailed. You can always do personal service. You can do substituted service. You can do posted service. But for 60-day notices only, you can also, I believe, mail them. But I double check. I believe that's Civil Code 1946.
Yeah, that's 5 days if you mail it to the time period, and that's great advice too, Zach. About the attorney fees, capping those, because defense attorneys can step in if there's no cap on it. They'll step in. They'll take a case on contingency basis for the renter and fight back, and they'll be paid by you if you lose as the landlord. So.
And I've had defense attorneys sub into cases and just flat out tell me that's what they're doing, and it's just like, oh wow, okay. Really makes you want to do your homework and make sure you didn't mess up the case, because you could be on the hook not only for the filing costs and the time it takes for you to go to court, but you might be on the hook for the defense attorney's fees. And that guy for sure is not holding back on billing that case out. They will not be holding back.
Yeah, and Zach, your advice too on the making sure that you actually have the Tenant Protection Act exemption is very good advice, because one of the first things I do when working with a landlord who's going to sell is I ask for a copy of the rental agreement, and I double check to make sure if it's a property that's exempt from the Tenant Protection Act, that the appropriate exemption language has been given. And I would say 75 to 95% of the rental agreements I review from real estate agents, from property managers, and from landlords themselves, the box wasn't checked. All you had to do was check a box. It was not checked. So go ahead, Zach.
For the life of me, I don't understand why. Sometimes when you're designing forms, and we offer forms on our website, and when we're thinking about those, we want to make sure that the default case is always the one that's sort of most favorable, that you're going to catch the biggest number of people and put them in the position that they want to be. I don't know why they designed the form that way, that you would need to take an additional step to assert your exemption. Because it's a complete trap for the unwary. And had they simply reversed the form and said, check this box if you're subject to it, or have two boxes and say, hey, you have to check one of these. You know,
they still screw that up. Don't have two boxes. You can't do it with one box.
I've seen there are some forms where people check both. They check both subject and exempt.
Exactly. It's basic stuff. And I mean, once I see that, then I know the appropriate paperwork that we need to give in order to make sure that the notices are valid. Because you lose, if you don't give the right 60-day notice, you lose all that time, and potentially you're going to be accused of harassment and all that. So, all right, moving on to more questions. Anne is a landlord. Any way to charge a tenant at move out for carpet cleaning, or can I categorize it as sanitizing carpets instead? Do I have to clean the carpets if I can't charge the tenant? So there's a law that says that you can't charge tenants for carpet cleaning, but really what it says is you can't charge tenants for carpet cleaning if it's not necessary. So at the end of the day, and this is all rolled into the new security deposit law, if the carpet needs it, if they did an oil change, and I swear this is a real story. It's a second floor unit. Literally looked like they had rolled a motorcycle up there and done an oil change in the middle of the carpet. So that was one where actually carpet cleaning wasn't going to do it. They had to put in patches. But if the carpet needs it, and when you gave it to the renter, it didn't look like that, you can charge for carpet cleaning. So unless you guys disagree. They don't disagree. Carpet is too nice for rentals. Actually, go with friggin' LVP, a laminated vinyl product. That's where it's at. All right, so BMEP doc. So this is proof that I was talking about what I was talking about was real. You didn't have to admit it. I appreciate you tuning in, and I didn't mean to call you out on here. I didn't want anybody to know. But this was the person who had to drop the price by $100,000 to facilitate the sale of a tenant-occupied RSO property in Hollywood. And that's good. Another developer is interested. The problem is you're still under contract, I think, with the other person. And I didn't mean to call you out. It's just the problem isn't the landlords. The problem is the listing agent who takes the property on without understanding how to work with renters and or how the RSO works. That is they're opening themselves up to liability, because as a professional, if, for example, like if you guys suddenly decided to practice a different form of law than you are an expert in, and you're telling people you're an expert in that law, is that a problem?
Yeah, it would be, especially if you give bad advice. There's a reason why there's malpractice insurance. There's a reason why lawyers can be sued for malpractice as much as doctors can be as well. So, yeah, I mean, when it comes to giving competent advice, people shouldn't be giving advice in fields that they're not competent in.
Can you tell them I'm fired up about this? Sorry, I'm getting a little fired up. It's so frustrating. And then especially after the trade show yesterday, like there's people doing stuff they don't understand. And by people, I mean real estate agents. It's like, guys, come on. You can sell your mother-in-law's condo that she's moving out of. That's something easy. But don't step into this world where there's so many friggin' landmines and all it's going to do is hurt your clients. Okay, I'll get off my soapbox. Sorry. Okay, so this is going back to Only in America about paying the rent. We'll definitely pay the back rent if asked. But should I wait for the landlord to tell me the total so I don't overpay or underpay by mistake? So Kenny was basically saying, don't wait for the landlord to ask. Make sure you pay it. Try to figure out, I mean, you can ask what the amount is from the landlord. Right? I mean, the
Yeah.
landlord should give that number.
Yeah, so you should have a record for yourself in terms of like what your monthly rent is, and whenever you make payments, make sure that you have proof that you've paid, because there will be unscrupulous landlords out there as well that will either not give correct records or they themselves just don't give records because they don't have records and they're disorganized. And so, I always say this too: when you go to court, when you're going in front of a jury, when you're going in front of a judge, um, who are they going to believe? Are they going to believe the person that comes up and says, "I think it's this number"? I think it was that. Do you have a document for that? No. Do you have a ledger? I don't know what a ledger is. It's the worst. Um, or they going to believe the guy that comes in and says, on February 2nd, I paid this. Here's a picture of me with the certified check. On March 2nd, I paid this. Here's another picture of me smiling with the check, paying it off. Here's another picture of me on April 4th with the certified check, paying it off. I don't know why he gave me a notice for this, but I don't owe it. Um, Proof comes from good record keeping and documents that back up what you're saying. And the nice part about it is it adds to your credibility. You'll get away with people siding with you because they say, if this guy did it right 5 times, 6 times in a row, what's the likelihood he's doing it wrong the 7th time? Not very high. Now that you may have messed up on the 7th time, who knows, right? But the fact that you did it right 6 times in a row and you can show that adds tremendously to your credibility. And your credibility in court is what matters the most.
You've earned grace if you do it right several times in a row. So do you, question for you guys, because we're about to wrap up. It's already almost been an hour and we've had so much fun. So do you let your landlord clients go into court and let the judge ask your client for a ledger and you let your client say, I don't know what a ledger is? Would that be something that would happen with somebody you have?
No, we
That was a leading question. You could have objected to that leading question. And the reason I asked that question was they don't let that happen. When you hire these guys as pros, when you get Kenny, Zach, Raphael, or Christina, they're going to make sure that when you go into court, you're ready and you're not going to be surprised. They're not going to be surprised. So, anyway, tell me why the heck I should hire you guys. Because, well, here, let me say this first before you do that. So, a lot of people like to look at you guys and say, oh my gosh, how long have you been attorneys? You look so young. And it's true. They are young. They haven't had the law destroy their souls yet. They're still young. But what is most interesting to me, and I had this discussion at the show yesterday repeatedly, is the changes in the last 5 years since the start of COVID in landlord-tenant law. And I know this for a fact because I've been doing frickin' videos since the beginning of COVID. The changes in the last 5 years are unlike any of the changes we had in the 50 or 100 years before. Am I right, guys? Is that true?
Yeah, the past 5 years have had the most changes in this field,
Yeah.
and they are actually very onerous.
So if you're going to hire an attorney, you just want to make sure that they've been highly, highly active. If you're hiring an eviction attorney, make sure they've been highly active in the past 5 years. They've been in courts, not because they're being sued, because they're representing clients and they understand the law. Again, I'm getting fired up on this now. You guys know your stuff. That's why I'm partnered. I don't take partnerships lightly. That is why I'm partnered with you guys. And when I go to a trade show and I have the honor of being there with part of the team, I didn't get to have all of you, but I had Kenny and Christina, hearing your answers, hearing how thoughtful you are, it just reiterates and reestablishes why I'm excited that we're partnered together. And I don't make any money off these guys. This isn't a financial partnership. This is exclusively because you guys know what you're doing. You take great care of clients. And I refer all my business to you guys, even in places you don't want to go. Like you don't want to cover all of Southern California, but I'm making you guys do it because I know you know what to do. All right, so now you probably don't have to tell us why to hire you because I just said why to hire you guys. But Kenny, why should we hire you guys?
And thanks for the nice words, Christian. We really appreciate it.
Yeah.
But the thing of it is that what we offer, and I think that what's been lacking in this field is transparency and honesty. One of the biggest things that I've heard back from our clients was that we were absolutely transparent with our billing and where we bill, how we bill, and what's going on in the case. We don't sugarcoat it. We don't tell people, hey, like this may or may not happen, or we tell them this did happen or didn't happen. I find it astounding some of the reactions that I get when I tell people, "Hey, this is what happened." They're like, "Oh, thank you." Like no one, like I've had other attorneys and they don't tell me that stuff. And I'm like, this is communication 101. Communication in this field, I think, is lacking when it comes to attorneys that represent their clients in this field. And it may be because some of the attorneys don't know what they're doing. They might be either A, too afraid to take it to trial, or B, don't understand the law that is at play here. We've subbed into many, many cases where attorneys either are too afraid to go to trial or they mess up the case. And we tell those clients straight up, this is what we see. And we treat the case as if in a situation where we see an error, we assume the other side sees the error. And we tell that to our clients up front. This is a risk that you're taking by going forward. We want our clients to make informed decisions. If they're going to make an informed decision, they need to be apprised as to what is going on in their case. And at that point, the client can make a decision as far as what risk they want to take or what risk they don't want to take. There are two cases that kind of come to mind where talking about other attorneys that may or may not know what they're doing, or they've been doing it for a very long time, but they're still dropping the bag, there was a case that was ongoing for about a year and a half. It was the oldest case in that judge's courtroom for a year and a half. That plaintiff, that landlord, was looking for representation elsewhere. We subbed in, we got it to trial in less than a month, and we won that trial. That trial took a week and a half. It took a week and a half because we had to take the case based on what the attorney previously had filed, but we won that case. It took us a month to get there. That landlord waited a year and a half with their previous attorney. So, we got a resolution in a case that we subbed into, filed by another attorney. Another case that kind of comes to mind is that when we deal with other opposing counsels, we actually get calls from them asking us what their thoughts are or what our thoughts are on the case they just litigated us with. So
that's a compliment that they
that happens quite regularly.
They got their butts kicked, but they're still willing to come and talk to you guys.
The field is very small in eviction. Everyone knows everyone.
Yeah.
And you see the same faces. You see everyone kind of, you get the feel of what they're doing. So you want to go with somebody that is in the field, that knows what's going on, that isn't afraid to tell you what's going on and tell you what your options are. Because ultimately, when you don't tell people what their options are, you're going to get that case. You're going to get that 1.5 year case. You're going to get that case where nothing happens because no one knows what's going on. The landlord doesn't know what's going on. The attorney doesn't know what's going on. The court doesn't know what's going on. No one knows what's going on. And someone's paying money and losing time out of this. And that shouldn't be the case. And that's never the case with us.
I couldn't agree more. My very quick story was, and I had a client who basically hired the same attorney 3 times to evict the same person. Third time was a charm. Lost the first 2 times. I, not an attorney, had just been doing videos during the eviction moratoria. I could have easily told him that first case he was going to lose. Second one he should have won, but whatever. Third one he finally wins. And that was a huge eye opener. That was somebody who had many, many years of experience, many decades, and still took 3 times and charged for the first 2, even though they lost. All right, Zach, we're over an hour, but I want to hear from you because you're a super thoughtful dude. And what I love about you guys too, and your firm, is everybody's got their own personality. Everybody's got their own style. And there's really somebody at your firm for everyone, whatever you're looking for. So I want to compliment you guys on that. And tell me, Zach, why should we use you?
Yeah. So, Sun Tzu said that victorious warriors find victory and then seek to go to war, and defeated warriors, they will go to war and then seek victory. You have to know what you're doing before you do it. You can't do it on the fly. If you start this process and you don't know what you're doing, or even worse, you think you know what you're doing and you don't, you will not be successful. It's very unlikely that you'll be successful. Okay. Sun Tzu was writing about China thousands of years ago, but it's still applicable today. You have to know what you're doing before you do it. So call someone who knows.
Very well said. And I would venture to say that LA eviction courtrooms are more dangerous than Chinese battlefields thousands of years ago. And I do not mean that. I'm not exaggerating. I think it's more dangerous.
Worse. I have to say the parking
is worse.
Yeah, the terrible thing is that, when you lose, it's not over. And the LA court system tells you, come back. I'll see you next week. I'll see you next month. I'll see you next year. And there are some landlords, I see them year after year, and it's the same property. And I'm thinking, who are you hiring? Who's doing this? I've seen some people. This one individual, I've seen her at the Long Beach courthouse for the past 4 years. 4 years. I don't understand what she's doing. And she's trying on her own. I respect that, but after 4 years of trying on your own, I imagine that something needs to click in saying this is outside of the bounds of what I'm able to do on my own. So if you like spending your time in court for 4 years, who am I to say if that's not a good use of your time?
Well, California is a state where you do not have to go to law school to pass the bar. You just have to have experience and become an attorney. You have to pass the bar. So maybe she's attempting to become an attorney by losing for 4 years straight. All right. I've kept you guys long enough. Letitia Campos has a question about a single family home in Bell Gardens. Letitia, reach out. We've got contact info below. You can reach out to these guys or you can reach out to me. We can fill you in on that. But really appreciate you being here. Appreciate you guys coming to the show. We have another show we're going to be in May. I'll get some info on that. I friggin' want all of you guys there. I want the whole team to show up. I know it's hard because it's middle of the week and somebody's got to be in court, but I want you guys there. So anyway, thank you for being here. And thank you for all the support you do for the people on my channel and taking hours, literally hours, to answer questions for free and get nothing out of this. That's another reason I love you guys. All right. So take care. And we will see all of you very soon. All these fans out there watching us, we'll see you at that show in May. All right.
Thanks, guys. Can't